So let us pray. We give thanks to you, O Lord our God, for all your servants and witnesses of time past, for Abraham, the father of believers, and Sarah, his wife, for Moses, the lawgiver, and Aaron, the priest, for Miriam and Joshua, Deborah and Gideon, and Samuel with Hannah, his mother, for Isaiah and all the prophets, for Mary, the mother of our Lord, for Peter and Paul and all the apostles, for Mary and Martha and Mary Magdalene, for Stephen, the first martyr, and all the martyrs and saints in every age and in every land. In your mercy, O Lord our God, give us, as you gave to them, the hope of salvation and the promise of eternal life, through Jesus Christ our Lord, the firstborn of many from the dead. Amen. Well, good morning, everyone, and welcome to the forum today. We have this morning, our Chancellor, Andrew Brooks, who is going to talk to us about estate planning. As I'm sure many of you already know this, but if you didn't, our prayer book commends this process to us. Page 445 of the prayer book reads, "The minister of the congregation is directed to instruct the people from time to time about the duty of Christian parents to make prudent provision for the well-being of their families, and of all persons to make wills while they are in health, arranging for the disposal of their temporal goods, not neglecting, if they are able, to leave bequests for religious and charitable uses." So that is what we are doing today. We're talking about how to dispose of your temporal goods when our temporal bodies are no longer able to care for them. You may find it interesting to know that this directive in the prayer book comes at an interesting place. It comes at the end of the section for Thanksgiving for a child. So if you are concerned, if your thoughts are that, I don't really need to do that, the direction of the prayer book is that that from the beginning of life, this should be our concern. Even as we give thanks for newborn children, our concerns are for how to make provision for the end of life, as we even think about the beginning of life. So with that, we'll turn it over to Andrew Brooks, who is our Chancellor, as I mentioned, and an attorney, and has done estate planning many times and will lead us through this process. It'll take me just a moment to get the PowerPoint up. And with that, I'll turn it over to Andrew.
Good morning.
Good morning.
Thank you all for joining us. The PowerPoint we're going to use, of course, the dirty secret with PowerPoints is it's really to help me more than it is to help the audience, to make sure we cover everything that we wanted to talk about. This particular PowerPoint was created by Brad Lovelace, who has made this presentation over a number of years to the cathedral and community. And I want to thank him for all of that good work. But like any of those forwards in books, all the mistakes in this are my fault, and please blame me for them. In a previous life, let's see, I've been a lawyer now for 30 some years. In a previous life, I was a JAG officer, and a lot of the work that I did there involved briefing deploying soldiers about this very subject and preparing them to go into harm's way, and give them some comfort and peace of mind that their affairs were in order if something happened. But I like to tell them that any one of us could get it on the freeway going home from work any night of the week. So it's important to be prepared with this sort of thing. The one particular horror story I'll share with you is a friend of mine died at a very young age, very unexpectedly. And his mother had predeceased him earlier that year. So he had not gotten his affairs reordered. And as a result, when he unexpectedly passed, everything was left, because he hadn't made other arrangements, everything was left to his father. And his father was the one who was in charge of all of the arrangements for funerals and memorials and all of this. He had not spoken to his father for over 15 years because they were so estranged. So the lesson there is to please do not delay and make sure that you have thought ahead and make arrangements on this. Jeff, why don't we go ahead and can we share the PowerPoint? I'm not seeing that. Oh, here we go. There we go. So you can do a lot of complicated estate planning strategies. Primarily, those are driven in order to save or delay estate taxes. And in the time I've been a lawyer, it's been quite surprising to me how the entire movement has been to reduce the number of estates that are subject to estate taxes. So the complicated strategies typically do not, well, the complicated strategies apply to fewer and fewer people, but you still need to make some planning. And we're not going to talk about the complicated stuff today. We're going to talk about the basics that apply to pretty much everyone. Let's go ahead and the next slide there. So estate planning is not just about what happens after you're gone. It's also important to prepare for what happens if you're not able to manage your affairs while you're still alive. It's the fortunate of us that do not ever find ourselves in a situation where we are not competent to manage our affairs. The estate planning package, we'll call it, that we'll talk about in a minute, also addresses these pre-death issues and what happens for your care and your health or your daily care if you're not able to manage it, what happens for your financial affairs, and not only for incapacity, but even convenience. After your death, that's when some of these other things kick in, and it's what happens to your assets, who is going to decide that the stuff gets to the right people and be in charge of that. What are your preferences for memorials or burials or cremations and all of that sort of thing. And then we can talk a little bit about the estate tax and caring for children and spouses and pets after your death as well. All of those things can be addressed in that package, and all of these are the sort of things that you want to give some thought to as you proceed through this process if you haven't done so already. The three types of packages that you'll often see is do nothing, a simple will, or a living trust package. The do nothing option, in fact, you probably should do something here. The intestate succession, the state of California has an estate plan for you. It may not be what you want, which is why you want to do some of these other things. I can assure you, if you want to remember the church, it will not remember the church. Generally, well, we'll talk about what the pre-planned statutory scheme is in a minute. But you can, if you don't have a lot and the statutory intestate succession strategy is acceptable to what you want, you may not even need a will. You probably do want to have a durable power of attorney, which is the document that we'll talk more about in a moment, that allows someone to manage your financial affairs, and an advanced health care directive. And that's the document that says who will make medical decisions for you if you're not able to make them for yourself, and what you want them to do. Pretty much everyone should have a durable power of attorney and an advanced healthcare directive. You may also want to do a will, and you may also want to do a living trust. And we'll talk more about each of those in a moment. If the living trust package, you'll notice, includes a will, the difference with the living trust is that the will scoops up anything that you forgot to title in the name of the trust, so your trustee can manage it. And it says whatever I own in my own name at the time of my death goes to the trust. And that makes it a lot easier for the trustee at that point. If we can go to the next slide. As we proceed through these things, what we're going to talk about is why you would want each one of them, what they do, and who is going to be the person that is actually doing it under these documents. The first one let's talk about is a durable power of attorney. And it is a document that says my agent or attorney in fact can sign like I'm signing, and I am responsible as if I signed it. Generally, you want to give this only to someone that you trust absolutely. It is also known as the license to steal. And I cannot begin to tell you how many horror stories I heard when I was dealing with the military of people that were deployed and came back and found that their dear beloved spouse had developed a new boyfriend or girlfriend, hawked the house, developed a drug habit, and taken the money and disappeared, or some similar problem like that. So you want to be very careful with this sort of document. This document is only effective during your life. So upon your death, it expires and goes away. The who is that attorney in fact, and that's the person that you're trusting to manage your affairs when it becomes effective. The durable powers of attorney come in two flavors. One is a springing power of attorney, which means it becomes effective generally upon your disability, and you need to give some thought as to how that disability is determined. You may things you often see would be things like, a doctor's letter or two doctor's letters or something like that. It's awfully complicated to require a court to actually find that you're incapacitated. So that would be the trigger then that allows a springing power of attorney to take effect. The immediately effective power of attorney doesn't require any of that. The moment you sign it, your agent can now use it to manage your affairs at your liability and exposure. So again, these are very powerful documents, and you want to make sure the person you're trusting is worthy of that trust. The power of attorney only addresses documents that are not in a trust. If we create a trust, we'll talk about that in a minute. It would allow you to deal with credit card companies or deal with the IRS and things like that. It would also allow you to maintain gifting patterns if it's properly, or well, if it's drafted to allow that. Now, the gifting patterns can include both charitable gifts or gifts to family members. And we'll talk a little bit later about the dollar amounts and why gifting is done and the gift tax implications of some of those things. The next slide is going to talk about, let's see, we've hit most of these things. In doing that durable power of attorney and who you trust, you may want to have someone who's local, just because it's easier for you to deal with that if you're not completely comatose. You can also address the care of pets and various things like that going on. And one of the things, well, the two final bullet points there that we should probably mention is that this is the document where you can nominate a conservator. And a conservator is someone who operates under court supervision. And when you're no longer able to take care of yourself, they will be charged with the responsibility of either taking care of your person, who is responsible for supervising the rest home and the nursing home and that sort of thing, or your caregivers, and the estate, which is your financial affairs. And there's an annual report to the court, and they would be scrutinized. And so there's a little bit more of a check and balance with that. It is, however, a slightly more public and certainly more cumbersome and expensive process to have that conservator. So if it's not necessary, you may not want it. What that also means is you no longer have the authority to act yourself. The conservator is making those decisions for you. The power of attorney, you can still act yourself, including to revoke the power of attorney, as long as you're not incapacitated. So the power of attorney is revocable, at least until the point where you are incapacitated, which of course is when a springing power of attorney comes into effect. Next slide. The Advanced Healthcare Directive. This is another important document that you want to use or want to have available. The next slide is a rather amusing take on that. I don't want to live in a vegetative state dependent on some machine and fluids from a bottle, and at which point her friend unplugged the computer and threw out the wine. Most of the an awful lot of people want to not find themselves hooked up in that sort of situation, and they would like to be able to designate someone to give direction to their medical team, including direction on when to pull the plug. Next slide. Again, the who is going to make that decision is someone you want to give some thought to. And again, you probably want to have someone local, although that it's certainly not essential. It's often easier to deal and manage the medical team and whatnot when you need to, if there is someone local. This deals with the day-to-day and healthcare type decisions. Is it the plug pulling version, or is this, no, I want heroic measures, keep me alive at all costs as long as you can? It's a very personal decision, and it is your own ethical calling which you want to do, and they can be drafted either way, and some of them can be very personal and detailed. If you want to do not resuscitate orders, DNRs, oftentimes you want to reflect those in the POLST document, and that's that bright pink form that they want you to put on the refrigerator. That is the physician order for life-sustaining treatment. And it's a pre-printed standard form that your doctor will sign. And if the paramedics come to your house to resuscitate you and it's filled out to indicate you do not want to be resuscitated, then that document, again, they want it on the refrigerator because that's where they're trained to look. That's where they will look for that document, and they will then follow those instructions. And that discussion on end of life decisions you want to have with your medical team beforehand, so they are clear on what your desires are and that is recorded. Now, the Advanced Healthcare Directive, sometimes also called a medical power of attorney, that's the one where it is typically not in that emergency situation at home where the paramedics have shown up. That's where you're dealing with the doctors, you're in the hospital, what's going on, how do we manage that ongoing care? Be aware when you're dealing with this type of stuff that your desires for burial versus cremation and organ donors and funerals and all of that, they don't necessarily end up in this document. And you want to make sure you've had those discussions with your family members before that they have to make those decisions, so they know what your desires are. And even at the end, when it comes time for that organ donation, if there's any question, the group that is going to take the organ donation, they generally err on the side of not doing that. So you want to be very clear on what your desires are. Next slide. So we've talked about the financial power of attorney, and we've talked about the medical power of attorney or Advanced Healthcare Directive. What about the stuff? If you do nothing, as I said, the state of California has an estate plan for you. Next slide. California is a community property state. There are about 15 states that are community property states. Interestingly, they're typically the former Spanish states, California, Arizona, New Mexico, very much the Western United States. Property is typically either separate or community. Community property, well, the separate property is what you had before you got married. It is what you get by inheritance or gift, or it's income off of that separate property. So as a general rule, this often comes up in divorce situations, which you may be familiar with. Everything else is pretty much community. If it is acquired during a marriage, it is presumed typically to be community property, unless it's one of these things we just talked about that's separate property. You can move things from separate property to community property, or community property to separate property. You want to be, you need to consult with an attorney in order to make sure that's done correctly. It probably needs to be done in writing. It probably needs to be very specific and describing what it is. It's easy to screw that up, and I've had to deal with some problems in estates as to which is which, because my separate property goes here and my community property goes there, and well, what is the stuff now we're looking at? So you want to make sure that if you intend to make it one or the other, you want to make sure it's accounted for clearly, and that if you're moving it from one to the other, you do that in a way that is effective so that your desires, in fact, are able to be implemented. Next slide. So if you do nothing and you don't have a will and you haven't set up a trust, where does the stuff go? If you are married, your community property all goes to your spouse. If you have separate property and no children or other family members, it will go to the spouse. If you have other family members, your separate property will go 50% to your spouse and 50% to your child, if you have one child. And if you have more than one child, it will go 1/3 to the spouse and 2/3 to the children. So that you'll notice there's nothing in there about charities or third parties or the church or anything else. So if that is not what you want for your estate plan, you need to do something else. If you are single and you're not married, then it goes to your children in equal shares. If you have no children, it goes to your parents in equal shares. And if you have no children or parents living, it goes to your siblings and in this greater expanding circle of your closest relatives. And there's a list of how close the relatives are and how you determine who's the closest ones and who gets it. This can create issues. When I was briefing the soldiers, it was surprising to me. Well, they come in two flavors typically. One is my spouse and my children are my world, and I want to do everything possible for them. I don't care anything else. Take care of the kids and the wife, or the husband. Alternatively, there were a few that were, well, I think I have maybe 3 or 4 kids from 4 or 5 women, and I'm kind of married. No, you either are or you're not. If you do not have a decree of final dissolution of your marriage in the eyes of the state, you are still married, and that can create estate planning issues. Next slide. Why would you not want to do a will or something else for arrangements? Well, it's free. It's easy. If you don't have children and pets and it's a small estate, and or maybe it's a temporary situation because you're going to do something, all of those would be reasons why you wouldn't necessarily need a will. You do not need a will to go through probate, which is the process at the court to supervise the distribution of your assets, and you may in fact need a court order to transfer assets. Right now, the state of California allows you to transfer up to $166,250 without getting a court order from the probate court. That does not include items that are not in your name, such as 401ks and IRAs and insurance policies, or a car. There's a separate process for the car. So that's the definition of small estate if you're looking at those sort of things. And there's a very shortened version of the paperwork to get those assets transferred. If you have more than that amount, and pretty much anyone in California with a any sort of a house or a condo, well, now you're talking about needing to do something more extravagant. There are options if you do not have a will or a trust and you want to make some charitable gifts. The pay on death accounts can, upon your death, they will go to the person you've designated as the beneficiary. The retirement accounts are governed by the beneficiary designations, and that's the IRAs, the 401ks. If there's a pension with a death benefit, you may be able to direct those to a charity if that's what you want by your beneficiary designation. That means it would go to them on your death, and you wouldn't have to do a will to do all of that. Joint tenancy is another method, joint tenancy with right of survivorship. The survivor then automatically takes whatever you had. It's assumed to be 50-50. So upon your death, the joint tenant with right of survivorship gets the other half, and now they're the owner of all of it. You often see that on deeds for real estate. And that section 13100 is that $166,000 number I mentioned. And again, that's the short form affidavit process to transfer assets. So if we talked about the do nothing, no will or trust option, and that going through intestate succession. The other two packages that we'll talk about briefly then are the will and the living trust. So the will package, you've all seen in the movies, reading the will, which actually is not a thing, but there is a written will that appoints an executor, and that executor then is in charge of marshaling your assets. They get a court order appointing them. They marshal your assets, pay your liabilities. There's a claims process, and then whatever is left is distributed to the heirs. If it's in a will, a written will, it'll say who gets what. And that's the basics of a will. It is under court supervision. It is cumbersome and complicated, or it can be, and it can take. Well, I've got one right now we're on the third year of it. We've been able to distribute a lot of the cash out to the beneficiaries, but we still have some work to do. The IRS has finished their audit, so hopefully we'll be winding it up quickly. Ordinarily, the process would take about a year. Interestingly, the timing on a will or a trust is probably not that different, however. It's a probate is public, the will is public, the trust is private, confidential typically. And if the fees for the executor and the attorney are set by law, which if it's a large estate, it can be a very large number. If it's a very small estate, it's on a sliding scale by a percent, so it can be a very small number. Let's do the next. So when you're preparing the will, even if you've got a living trust, who should be the executor? Again, that's someone that you want that you trust to implement the decisions. The important thing on both a trustee of a trust and an executor under a will, they're not working for you. At this point, you're gone. They're really working for your heirs and the beneficiaries, the people who are going to get this stuff. So you may be tempted to say, well, I have this very close friend and I know that they will implement my desires and they would be very good and I trust them. But remember, when they say yes to that, they're doing you a favor and you're not going to be there. So you may want to consider who should be doing that, and should it be one of your heirs? And again, the conflicts with the blended families and whatnot, that can be a very subtle decision as to who should be the executor under a will or the trustee under a trust. There is a procedure for the executor to post a bond. That typically is not a lot of money. It is expensive to get that bond and post it with the court. The bigger issue is whether someone is bondable or not. If they have a criminal record or something, they may not be. Then that may be an indication you don't want to trust them to be the ones to manage all of the finances and get it to the people that are supposed to get that stuff. Finally, in a will, you can nominate a guardian for any children you have. And the guardianship of the children that's the person who is now in charge of the kids and taking care of them and has legal authority to make sure they're going to school and to take them to the doctor and all of that stuff. And that's typically done in the will. And the courts will often look at that nomination in the will and follow that for who is in charge of the kids. A will does not need to specify in detail who gets every tchotchke and small item of personal property. That's often done by a written memorandum. There are some rules as to how much can be designated by a separate written memorandum. That can't be cash or business property. It has to be personal property. And it can't be more than $25,000 total, and it can't be more than $5,000 each. But that allows you to change your mind and decide that instead of Aunt Susie getting the china set, it should go to the niece or to the nephew or something like that. And it's easier to modify that written memorandum than it is sometimes to go down and redraft the will. Not that that can't be done, but that's the way you often handle those kind of personal property items. Next slide. Why would you do a will instead of something a little more complicated like a trust? Well, it's cheaper, it's less overhead from an administrative point, perhaps. Again, if it's below that 166,000 number, you don't need to go to court, but you can make accommodations for other people than your immediate family that the state of California thought should get your stuff. You get to decide who gets your stuff. It's often, it'll work best if you don't have any real estate. You'll need to go to court if you have real estate that's passing under a will. And it does provide the court supervision to make sure that the stuff is actually done. Next slide. So the third package, the third option would be a living trust package. Next. So what is a trust? And the next slide, well, you have trust property that goes to a trustee for the benefit of a beneficiary. I'm running out of fingers. The benefit of a beneficiary. Those are the three elements of a trust. Now, they can sometimes be the same people. The trustee and the beneficiary can be the same. The trust is basically the rule book about who gets what and how it's held, and do you have to wait till you're 25 or 45 to get it? and what happens in the meantime, and what power does the trustee have, and what should they be trying to do. Next. So pre-death, you can set up that living trust, and living is another way of saying revocable, or I can change it while I'm alive, or while I'm competent. So I have a living trust. I'm sure many of you do too. And that allows me to manage my stuff for me while I'm able to. But before I die, if I become incompetent, a successor trustee will step into my shoes and can manage my stuff for me, but they're the ones managing it. And so they can make sure that the bills are paid and I'm taken care of, and all that financial type of management during my lifetime if I'm not able to do that myself. It is private. The will and the probate process and the conservatorships and guardianships are under court supervision. So at least some of that is a public knowledge. Now they have some confidentiality at the court, but it's less than a trust would have. And it avoids the whole probate process and going down to court typically. So it's that less administrative overhead. After I die, as it says, for the super wealthy, you can do some estate planning to minimize the estate tax. In the 30 plus years I've been a lawyer, they have increased the exemption before the gift and estate tax kicks in. It is now indexed for inflation. Last week, the IRS announced the new numbers for 2021, and the new number for how much money you're allowed to give away either during your life, and there are little asterisks there, we'll talk about that in a second. The amount of money you can give away during your life or at your death is now $11.7 million each. That means a married couple has 23.4 million that they can give away. And what the first person to die does not use of that combined amount, the surviving spouse can use. So we have what we call portability now for that total exemption. And I said there's a little asterisk there because you are allowed to give away $15,000 each to each person. So if you have 3 kids and a married couple, both mom and dad can give $15,000 to each one of the 3 kids before the gift tax kicks in. And the gift tax and that estate tax is combined. So if you're giving $14,900 each year to each kid, you ignore that. If you're giving $25,000 each year to each kid, each of you, well, anything above $15,000 now counts against that 11.7 million. Those are large enough numbers that at this point, that sophisticated estate planning stuff is generally the very high net worth individuals. And a lot of people, it just is irrelevant. But you still want to probably have a living trust, or at least a will, to take care of all of these other things, including the pre-death stuff. The other reason after death is if you need to end up managing property, you cannot give a lot of property to minors. And it's been my experience, at least when I was growing up, that 18-year-olds who inherit a large amount of money just use it to buy fast sports cars that they wrap around palm trees. And it doesn't end up very well. I had one story, one experience a while back where the very wealthy doctor and his very smart nurse wife, second wife, She was very mature at her age, and she didn't think it was a problem at all to give the kids the entire inheritance as early as 25 years old, perhaps. He remembered what he was like at 25 and wanted them to hold on to the money in trust and only have the trustee distribute it as needed until the kids were 45. So it depends on your kids and your own family situation. And frankly, it depends on, like the final bullet point there, those blended family second marriage situations, because the trust is how you can make sure that the first family is taken care of or the second family is taken care of, because you typically, that's kind of oftentimes where some friction can evolve. And again, there's no magic formula for any of this. Every family and every individual is unique and different, and you want to address your needs. The trust gives you a lot of flexibility in order to do that. Next slide. Well, we talked about estate taxes. I did not update this, the slide. The number for next year, like I said, was 11.7 million. It's gone up a little bit. There are special situations for farms and businesses that you don't have to pay it all within the 9 months after death if you are above that amount. We should all be so fortunate as to have to be worried about that. If you are, you shouldn't be relying on a free seminar like this for your estate planning. Next slide. So you decided you wanted to do a trust and you had a trust prepared. The trust is useless unless your property actually is held by the trust. So that means you need to go down and record a deed with the county recorder to put the property into the trust. So instead of John and Mary Smith, often tenants in common with right of survivorship, or these days community property with right of survivorship for tax reasons, you'll now go to John Smith and Mary Smith, trustees of the John and Mary Smith Living Trust, and their successors. So if John dies, they file an affidavit of death of trustee, and Mary is now the sole trustee. And it doesn't have to be, the married couple. Anyone can do that sort of thing when they're setting these up. But the property now is owned by the trust and can be managed by the trustee, whoever that ends up being through time. Certificates of title need to be changed. It's easy enough to move vehicles that you don't often put vehicles into a trust, but you can. There's certainly no reason not to. Anything else that has a certificate of title, you want to make sure that that's the trust is now the owner of that, so it's easy to manage. Signature cards at the bank will want to sometimes close that account, open a new account under a new number, and that'll be the trust account, and they have a different set of forms that you'll sign, so you get that done. Assignments of partnership interests or whatever else you have. One of the things that you want to make sure is accurate and complete is, we call it Schedule A. So the trust instrument has a whole bunch of stuff in there about who's the trustee and how they manage it and what happens on death. But the assets that are in the trust typically are listed on that Schedule A at the back of the document. And that's important because that shows your intent that this asset should be in the trust, even if we missed doing the deed over here or the certificate of title or making an assignment. And there's a process in California where you can actually go to the probate court and get a court order. And if it's listed on Exhibit A and you meant it to be in the trust and you missed it, they'll put it in the trust, and now it can be managed by the trustee instead of having to do that probate procedure that we talked about. It's important to note that retirement assets, that IRA, that 401k, the insurance policy, those are not owned by you. You have a contract interest in them, and those do not pass by the will or the trust they pass by a beneficiary designation, and that's important that that be kept current and that you periodically check that and it be updated. And they have recently changed for IRAs, for example, the payout period. It used to be able to be stretched out for the life of the person inheriting it. They've shortened that, so the IRA now lasts for, I believe it's 10 years after your death. So it's important to periodically review these things, but it's also important that those beneficiary designations are accurate. Sometimes you put everything into the trust, oftentimes you don't, and it'll go directly to the beneficiaries you want, so that they can have that survivor IRA and stretch it out tax-free for another 10 years before they have to pay the income tax on that. Next slide. So who should be your trustee? We've talked about that a little bit. It can be the surviving spouse. It can be that trusted friend or family member. Again, remember that trusted friend is not doing this for you at this point. They're doing it for the people that are going to inherit this stuff. And it can be a pain and a burden. So you want to be very careful in selecting who you want to be that trustee. Sometimes a bank is the best situation. Banks are nice. They're expensive. They may not be as responsive, but they have a very large balance sheet. And if there's a problem, they can write you a check and fix it. A trust company is typically, there are special companies. They have to be licensed as a trust company to be a trustee. They can be a little bit more responsive sometimes than the institutional banks, the big banks. They are also expensive, like the banks can be. The banks and trust companies will have a posted schedule of their fees, and it's not cheap. It is a sliding scale, and it is usually a percent of the assets under management, and it's a smaller percent the bigger the estate, but it still can be a lot of money. And finally, you have a private professional fiduciary. That's an option. Those are people licensed to be trustees or fiduciaries by the state of California. They are very good. They're typically more responsive. They're typically less expensive. The problem there is they are typically smaller shops. So you don't have the depth of management. If many of them are solo practitioners, so it can be complicated if they get hit by a bus. What is their succession plan? Now, not all of them are. Some of them are multi-person offices and multi-location offices, and they, if this trust officer is not able to fulfill those duties, you have somebody else. Let's talk about when you're actually drafting that trust instrument. We talked about the flexibility of the document. Trusts generally come in two varieties. One is a revocable trust, which means you can change it, and the other is irrevocable. Typically on your death, it becomes irrevocable, at least as to your property, and that's it. You're stuck with what it says then. You want to be sensitive to the impact of your decisions in that trust or will, for that matter, on your friends and families and beneficiaries. My very successful child, I'm not leaving anything to them because they don't need it, and the younger one who's never amounted to anything does. You want to be very careful with those sort of decisions because, yes, the kid that has the challenges may in fact need it, but the one that you didn't leave anything to now thinks that, mom and dad didn't love me. And so again, it's a very personal decision depending on your family circumstances, but the trust agreement can be very customized and pretty much accomplish whatever you want in that regard. Taking care of pets, you can leave money behind for someone to take care of that long and loyal pet that is surviving you. Memberships and gifting, you can give money off the top to, I want to leave X dollars to specific friends, or that cherished piece of whatever to a friend or family member. They get this piece. All of that can be addressed in the trust document. You can also address how that incapacity is determined. We talked about that earlier. Is it 2 doctor's letters? Is it 1 doctor's letter? Does it require a court order? How does that get implemented? And finally, we talked about the bonding issue, but the no contest clause, and you probably want to include that in whether it's a will or a trust, but you need to make sure there's some skin in the game, so to speak. Threatening that they lose everything if they contest the will, and you left them $1 because you wanted to make sure that they knew they weren't forgotten, that doesn't really, so what? What have I got to lose? If they're getting 1/3 of that apartment building and they lose it if they think they should have gotten 1/2, and it's a big enough apartment building, then perhaps it has some teeth. Let's go next slide. With a trust, you are going to want a will. As I said earlier, we have what we call a pour-over will. And that says anything I missed putting in the trust or listing on that Exhibit A that I own at my death goes to the trust. And then the trust, the confidential, private, detailed arrangements, that is what will govern what happens to my property. And the will just gives the court the authority to transfer whatever assets I missed and was in my name into that trust to be dealt with. Next slide. Well, we made good time through this. You don't want to try to do this yourself. LegalZoom is out there. Lawyers, we love LegalZoom because there ends up being problems that we then have to fix, and you have to pay us. It's important to do it right the first time. It'll make things go a lot smoother. Now, you may not care if you're gone, but the people that you're trying to take care of may care very much. So you probably want to consult with an attorney, and I'm the cathedral's attorney. So if you're remembering the cathedral in your plans, I'm probably not the right person to talk to, but we can get you pointed perhaps if you have specific questions. There are many very competent estate planning attorneys in town. Don't overplan. That dead hand control where I want to make sure that this is what happens regardless, well, after you're gone, that can be very difficult to implement effectively. Now, you may need to protect people from themselves on occasion, but don't overplan on that. The relationships, again, the people involved in this scenario much better than anybody else, and try to keep that in mind while you're making plans on who gets what and how it's done. Communicate with people. The horror story there is the very wealthy family that left everything to charity, and the kids are then standing around who thought they were going to get everything, or at least a big hunk of it. And when they didn't get much, and it all went to Dartmouth or whatever school it was, I can't remember the details of the story, but when it all went to the charity, the kids are like, well, didn't mom and dad love me? And that can be some real devastating things unless you've communicated beforehand and prepared them that this is why we're doing it and this is why it's important to me, and no, it's not the fact that I didn't love you, but this is why. So you may want to make sure that there are no surprises there. Again, that depends on the relationships and the specifics of your situation. And finally, this is not something you do and put aside and never look at again. As your life changes, as the kids grow up or the partners come and go, divorces, marriages, births of additional family members, deaths of family members. This is something that you want to periodically review. We recommend you review it about every 3 years. I think part of that is because we know people don't, and that means they'll look at it every 5. But you do need to periodically review this sort of thing. With that, that concludes our prepared remarks. If there are questions, I'm happy to take them. I don't see anything in the chat, but if there are things we can address, and I know, Jeff, you wanted to talk about some things as well. So I'm here as a resource, and I think we have another 30 minutes before the next service.
Yeah, I just encourage you to come off mute if you'd like to ask a question or ask for clarification. And I'll just reinforce, I know we have some physicians in the audience who may want to chime in on this as well, but the communication, not only about your will, but about your medical power of attorney. In the hospital, there's nothing worse than having a patient who is unconscious or unable to communicate, and their family for the first time learns of their intentions for medical decisions. And then the agent is the only one who knows about those intentions and has to have some kind of heated conversation or tension with family who are trying to implement, the agent is trying to implement those decisions. So for your medical power, your medical decisions, I really encourage you to have lots of conversations with your family about what you want for yourself before your family is in the position of having to live through the experience of having those decisions implemented.
You may all recall the Terry Schiavo case a few years ago where they dragged that poor woman through the courts and Congress got involved and it was just awful. She was in Florida. Florida allowed oral healthcare powers of attorney. So the husband said, no, she was very clear. This is what she wanted. And the parents said, oh no, she would not have wanted that. We're very clear she did not. And there was nothing in writing. If they had had a written document, you would have never heard of that case and there would not have been a problem.
I'd like to chime in as a physician and psychiatrist who used to serve as in the medical. I was fortunate to work with a very good team that would meet with the family about end-of-life decisions. But what seemed particularly problematic to me is when they would, leave the family with the decision about whether to remain on the ventilator or not. That really should be a medical decision. That the medical team will institute a treatment if they feel they can reverse the course of the illness. And so whether or not to put in an IV or to give, a certain drug should not be, that really burdens the family when they're already very stressed. So my recommendation is that you leave the medical decisions up to the team. Certainly they do it in consultation with the family, but the family shouldn't be burdened with the day-to-day medical decisions. So to leave it up to the medical team that, we're instituting this treatment because we think it can reverse the course of the illness. And if we don't feel like it has a reasonable chance over time to reverse the course of the illness. And they can also make the decision about what's needed to keep the patient comfortable. So to leave it all on the burden of the family when they're already grieving, I think and I've seen families really suffer from that. It's not the best way to go.
Agnes, did you have a comment or question?
Yes, I did. Andrew, when my mother died, her will specifically said no bond was required. I was the only beneficiary, the only heir. And the state of California insisted, because I lived out of state, that I had to bond myself against myself, which I thought was ridiculous. Is that still the California regulation?
Yeah, they like to have someone who they can get their clutches on. So if you had lived in California, that would not have been an issue.
It just didn't seem sensible to have to pay an insurance policy against myself.
I'd like to reinforce the communication part of things. Having your DNR, bright pink envelope, or whatever it is, somewhere extremely obvious is so important, because paramedics are obliged to do everything they can to keep you alive if they don't have instructions to the contrary. I've had parishioners who knew they were terminally ill and actually taped it onto their front door of their houses. And it said for the paramedics. And so that you can't be too obvious about those instructions, and communication about your decision on beneficiaries. Also, I've seen, I have personal experience of a difficult situation where the person who died decided without telling anyone to leave all the employment benefits to one child, because that child was in graduate school, the other one was earning a living. And it had the potential for enormous conflict, although I'm happy to say that didn't happen, but it could have been really ugly. So if you're going to do it, tell them why you're going to do it. And I emailed the PDF of all my trust documents to both of my sons, so I know they have them.
Mm-hmm. Yeah, none of this does any good if it's in the safe deposit box and nobody knows about it.
Right. I just wanted to say, Andrew, that it's been a wonderful presentation, and I wish you luck on your visit to your mother this weekend.
Thank you.
I'd like to put in 2 cents, Sue Kelly. I had an elderly relative that recently died, but in her retirement community, there had been an attorney and his wife that came by selling like a notebook, and that notebook had details about everything, you know, a place for them with tabs where you could put the information about your where your safe deposit box was, where the key for it was, where your will was, and so that we could use that as a resource to just find all this material after her death. And I'd strongly recommend people do something like that and have it have their children know about it, because it really was very, very useful. We had a number of keys that were for safe deposit boxes that no longer existed, but she had crossed out one and scrawled in the location of the one that was the active one. So that was invaluable.
My mother has a 3-ring notebook that she refers to as the Doomsday Book, and it has that sort of information. Now, I'm not sure it's as current as we'd like, but it has that sort of stuff, insurance policies. Don't forget the group insurance policies if you're a member of some national organization. Sometimes they have a death benefit for the lifetime member of, you know, the ABC club. All of that sort of thing. You're doing the people a great favor if you have that organized and in a fashion that they can find. Title all those things in the name of that trust you set up. It will make things go the way you want them to go if you've done that work ahead of time.
Your reference to a doomsday note reminded me that her husband had detailed every year what his outstanding wishes were and what properties he owned. And also he put in a list of what loans they'd made to each of the children. And so now they are able to use that against their distributive share of the estate after their mother's death, you know, some 20 years after their father died. So that's a good thing to have yearly.
Well, and putting your desires for the funeral or memorial service in the will is often not terribly effective because no one actually refers to the will until the dust settles and the funeral's over. So again, communication and make sure people know what you want beforehand is key.
Ideally, file those wishes at the church.
Ooh,
That's
idea.
very helpful. And we are supposed to be notified if a parishioner dies, and sometimes we're the first people to be able to provide information. Brooks typically knows where all that stuff is. And don't forget to tell people where to find your passwords.
yeah.
Yes.
Thank you so much, Andrew, for this presentation. When Bob's brother passed away, 48, with more assets than we realized, and no will, no trust, anything. So I had to do some fast learning. I ended up being the person who made sure things happened. And so a lot of what you said was very familiar to me, especially particulars about probate with the state of California, which we escaped because he had no real estate and his liquid assets were less than 150,000 at the time.
Mhm.
Most everything else was beneficiaried or would default to his parents. But so I knew and have had some experience with some of this, and we have a trust in it and are all set up that way, and grateful for doing that. And yet I still got a few little pieces of information that I wasn't aware of and reminders about good practices, even if you are set up around all of these. So I thank you very much for your time.
Glad to be able to be of assistance.
Yes, thank you,
Thank you.
Andrea. It was a wonderful presentation, and thank you all for joining. Many of you are already in our Legacy Society, which is the group of people that have included St. Paul's Cathedral in their estate plans. And if that is something that appeals to you, if you'd like to sustain the future ministry of the cathedral permanently by including a gift, no matter how small, no matter how big, in your estate plans, please let me know. We'd love to see how we can facilitate that. We have some information on the Legacy Society on our webpage under About How to Give, and I'd be glad to talk to you more about that. We thank you again, Andrew, and we will see you next week at the forum. We're still, I haven't heard back on our presentation yet, so I don't have a confirmed speaker for you next week, but we'll have something. And we will see
Andrew, that
you.
was very good.
Yeah, we'll see you at 10:30 if you haven't worshiped yet. Take care.
So long.
Thank you.